So thank you everybody for attending the local agency guide to implementing Section 504 Title II ADA program presented by the Caltrans Division of Local Assistance. Today we're going to be talking about some administrative requirements for the Title II ADA program. We're going to be having a follow-up meeting or a second training session in September of 2021 provided by the Federal Highway Administration that's going to delve a little bit further into the design and construction requirements of the ADA program. Our primary contact for this presentation, who will be providing the bulk of the presentation, will be Kathy Lee, the Civil Rights Coordinator in the Caltrans Division of Local Assistance, and her contact information is available on the screen. And since this is an ADA program, we want to make sure that if there is anybody with a visual disability, that they can read the screen, as the screen reader on the computers may not be able to read the pictures here in the presentation today. So on the left-hand side of the first slide, we have a beautiful picture of the state capitol. It looks like it's midsummer. We have a little breeze blowing, no clouds in the sky. This is why we pay the big bucks to live in California. And on the right-hand side of the screen, we have a tic-tac-toe kind of formation with 9 squares with various ADA symbols. In the top left box, we have a person in a wheelchair, signaling that if there is somebody with a mobility disability, there is accessibility to gain entrance to a facility. To the right of that, in the top middle, is a telephone typewriter. And to the right of that is an ear with a couple of wave bars above the ear, meaning that there are solutions for anybody with a hearing disability. On the far left-hand side in the middle is a telephone with waves coming out of the receiver end. This means the telephone is volume controlled. In the middle, we have the universal sign for ADA accessibility, just in ADA. To the right of that, we have a couple of hands giving the OK signal, one vertical, the other upside down. And that just means there is sign language spoken here. To the bottom left of that, we have a person with a cane, a picture of a person with a cane. That just means that there's accessibility for those that need assistance to walk based on visual disabilities. And in the bottom middle, we have a symbol for Braille, meaning that Braille documents are available here if somebody needs to read the Braille. And in the bottom right, we have excuse me, a CC or closed captioning symbol, meaning that anything presented today will be in closed captions. Next slide, please. So on this slide, we have our list of Caltrans Division of Local Assistance contacts. The three of us, Kathy Lee, Annette Goudot, and myself, we all work in the Program Reviews and Outreach branch within the Division of Local Assistance here at Caltrans. Kathy Lee is our Civil Rights Coordinator. Annette Goudot is our Civil Rights Analyst, and myself, Daniel Burke, I am the Civil Rights Manager. And we have contact information. The easiest way to get a hold of us is just to send us an email. We're usually pretty responsive within about 24 hours or so. And optionally, if you do need to discuss something in an email, it may not be appropriate just to write everything down or ask all your questions, feel free to give one of us a call here. Our mission here within the Program Reviews and Outreach branch is to provide training and guidance to improve stakeholder processes. We're hoping that this training will provide the information that all the attendees need to comply with the administrative requirements of the federal ADA regulations. Our vision within the Program Reviews and Outreach branch is to strengthen partnerships and civil rights through excellent customer service and user-friendly communications. So we're hoping by reaching out to you that we're developing a partnership, and what we're hoping for the agencies to get out of this presentation is to strengthen their civil rights by hopefully taking back some tips and improving upon their ADA program. And again, we hope this is communicated in a fashion that everybody can understand and that it's timed properly and it's the right length of time and difficulty, so that we can go ahead and make sure that what we're putting out is proper. And if not, we have our contact information where you may contact us with any questions or any clarification on anything that you had. Next slide, please. Thank you. So we're going to talk about our learning objectives today. We have a menu of about nine different topics that we're going to be covering today for the administrative requirements of the ADA. Before I get into that, though, it's important to note that with the Rehabilitation Act of 1973, also known as Title II of the Americans with Disabilities Act, the government was way ahead of California from the perspective of creating an environment of inclusion and equity for those persons with disabilities. The whole goal of the ADA program is to remove those barriers and give those persons with disabilities the proper opportunity to participate in decision-making and accessibility to public facilities. So in the first item that Kathy will be providing is Section 504 and ADA overview, and just talking a little bit about the federal requirements behind it. Kathy's also going to be talking about the ADA and Section 504 coordinator and what each agency needs to have in place to ensure that they have proper coverage to comply with the federal program requirements. Next will be the grievance procedures, meaning when somebody does have a concern with ADA required facilities. After that will be the ADA policy statement. Again, that's each agency's non-discrimination statement, and that they will comply and remove barriers to comply with the ADA program. Next up is a very important one. It's the self-evaluation plan. That is the facility or document used to remove barriers from ADA accessibility. And that kind of looks at an agency's entire universe of potential barriers that may impede participation and accessibility for a person with an ADA disability. Transition plan, which is, it takes the items identified in the self-evaluation plan, those barriers, and sets a timetable and feasibility of when those barriers will be removed and corrected by the agency. Kathy's then going to be talking about communication and why it's important to make sure that the public is able to participate and some ADA barriers that may be involved with public participation, as well as when you have information up onto your agency's website to make sure it is ADA accessible. We also have the ADA annual certification form. That's Exhibit 9C. That's due to the Division of Local Assistance, to your district local assistance office on June 30th of each year. And we also have the ADA design standards. We have a special guest speaker today. His name is Anthony Ng, and he's going to be talking a little bit, he's going to go into a little bit of detail on the ADA design standards and a design information bulletin that's very applicable, which Caltrans uses and may set the bar or a precedent for other agencies to use as well. On the picture on the right, we have in the top, I'm going to go from left to right here. We have in the top left, it appears to be a chaplain hovering over a desk that has potentially a bill that's being signed by former President George W. Bush. Directly below the chaplain is a person in a wheelchair with a mobility disability. And in the middle is former President George Bush signing hopefully what he's doing is signing a bill for Americans with disabilities into effect. Above him in the top right is former governor of Texas, I believe that's Ann Richards. And below her on the bottom right of the picture is another gentleman observing former President Bush signing a bill into law for those individuals with disabilities. I'm going to turn things over now to Annette to talk about some of the communication rules. Annette?
Okay, thank you, Daniel. This is Annette Goudeau. We are on slide number 4. Good morning, everyone. Thank you for joining us for this morning's webinar. I will go over our communication rules and what to expect in this webinar. Number 1, this webinar is being recorded and will be posted and available on the Caltrans Division of Local Assistance ADA website. Number 2, please type and submit questions in the Q&A box, which is located below on the panel below. Please also include the slide number associated to your question. Number 3, Questions and comments will be addressed during the Q&A sessions. We will have a total of 3 Q&A sessions throughout this training. The first and second Q&A sessions will address some questions submitted in the Q&A box. Our third and final Q&A session will address questions submitted in the Q&A box, and we will open up the floor for verbal questions, of which we will ask that you use the raise hand icon to be selected. Number 4, there will be a 10-minute break toward mid-presentation. And number 5, there will be poll questions throughout this training. I will now pass it over to Kathy Lee.
So my name is Kathy Lee. I am the Civil Rights Coordinator for Divisional Local Assistant. I'll be your presenter for the remainder of this webinar. So we're on our slide number 5. Slide number 5 read as Section 504 overview. And to your right, we have an image of Washington, D.C. Section 504 prohibits discrimination against people with disability in federal funded program and activity. It is the first law requiring curb ramps to be installed on federal aid projects to improve accessibility. It also applied only to those entities, which is local government, that receive federal financial assistance. The Section 504 was passed in 1973. It is illegal for any federal government, federal contractor, or any local government receiving financial assistance to discriminate on a basis of disability. Section 504 also obligates state and local government to ensure that individuals with disability have equal access to any programs, services, and activity receiving federal financial assistance. Okay. All right, so let's move forward to slide number 6. Slide number 6, we have the ADA overview, which is the American Disabilities Act. So before we move further to go over what ADA is, let's go over the different titles that's available in ADA. The ADA is divided into 5 titles. Title 1 is employment. Title 2 is state and local government, is what we will be training all you all today. Title 3 is public accommodation. Title 4, telecommunication. Title 5, miscellaneous. Okay. Now the ADA prohibits discrimination on the basis of disability in employment, access to public service, public accommodation, commercial facility, and transportation. It also applies to all entities, both public and private, regardless of funding source. Okay. It is also a federal civil rights law as well. And to the bottom, we have a note that states that Section 504 and ADA both help to provide disability protection. Okay. Now, let's go ahead and spend a little bit more time on the ADA on slide number 6. Okay. Now, the ADA was modeled after Section 504. Okay. It was made into law in 1990, but most of the provision did not take effect till 1992. So the ADA adds the strength of Section 504 by extending it to private institute, workplaces, and other institutes that were not covered under the Section 504. Okay, it gives civil right protection to individuals with disability, similar to those provided on the basis of race, color, sex, national origin, and age. It guarantees equal opportunity for individuals with disability in state and local government services, in public accommodation, employment, transportation, and telecommunication. Okay. Now, the biggest difference between Section 504 and ADA, Section 504, what we mentioned earlier on the previous slide, on slide number 5, Section 504 applies to federal funded program, whereas ADA, which is the American Disabilities Act, applies to state and local government funded program, which is Title II. Okay. We do often get questions, who enforces Title II of the ADA for local public agency? Okay. So for transportation related, ADA compliance on the local public right-of-way, the FHWA, which is the Federal Highway Administration, enforces Title II of the ADA through Caltrans. Okay, and Caltrans is required to perform and program review a randomly selected local agency on their compliance with ADA and as well as Section 504. And they report any deficiency to Caltrans Offices Civil Rights as well as FHWA. Okay. We also get questions, how are these local agencies being selected through a program review? Okay. The local agencies are selected by either the number of grievances or complaint they received. It could be a Caltrans, the district office requesting for technical assistance in behalf of the local assistant. It could be you may be a new agency, or it could be maybe an agency that have never received a program review. So that's where these are how we select the local agency for an ADA program review. Okay, so this allowed division of local assistance, which is us, to provide that training for you all. Okay. All right, so let's move forward to slide number 7. Okay. So slide number 7, before we move forward with this slide, just as Daniel mentioned at the beginning of this webinar, so this webinar provides local agency with the administrative requirement of Title II of the ADA Act, as well as Section 504 to ensure public right-of-way, roadways, and public facility do not discriminate based on the disability in highway transportation program, activity, service, and benefit to any general public. Okay, so the whole purpose of this training that we'll be training on you all today is based on the administrative requirement on Title II of the ADA and Section 504. Okay, so as we mentioned, we're on slide number 7. Slide number 7, we have the ADA/504 coordinator. Okay, the coordinator duties include, but not limited to, they assist in planning and coordinate compliance effort. They also assist in develop and distribute notice about ADA compliance. They're also the point of contact to respond to any inquiry from the general public. Okay, and on the bottom, we have a note that states that if a public entity, which is a local government or local agency, has 50 or more employees, it is required to designate at least one responsible employee to coordinate the ADA compliance. Okay, so if a local public agency employs 50 or more person, you must designate at least one employee to coordinate the ADA effort. Okay, so we often do get questions, how do we count the employees that we have in our agency? Do we count temporary employee? Do we count contractor? How do we count those employees to include with the 50 or more? Okay, so determining the number of employees would be based on your government total of employees. So what that means is that any part-time or full-time employees are included as part of the determination of 50 or more employees. Contractor or your consultants are not counted as employees for determining the number of employees. Okay, so in other words, the obligation is to count all employees of an agency regardless of full-time status or work assignment location. So the only individual that you will be counting for will be your contractor or your consultant. But full-time employees as well as part-time employees, you would count toward that 50 employees. So with ADA/504 coordinator, if you have 50 or more employees, you are required to designate one ADA coordinator for your agency. Okay. All right, let's go ahead and move forward to slide number 8. Slide number 8 is a continuation of the ADA/504 coordinator. Okay. Now the ADA coordinator also would be responsible, or they could have a designee that will coordinate requests for auxiliary aid, services, and reasonable accommodation of policies, practice, and procedure. Okay. There also will be the point of contact to either develop or update the grievance procedure. Okay. They also assist in investigating complaint, conduct a self-evaluation plan, and also develop a transition plan, including the curb ramp schedule. Okay. Now, right below that, we have a citation of 28 CFR, which is the Code of Federal Regulation. So when you right click on that, it's going to bring you directly to that regulation. So if you want to find out where all these requirements are coming from, it's coming from the Code of Federal Regulation. Okay. So the citation is listed right below on page number 8. All right. So in some cases, a local public agency may have a Section 504 coordinator, and they may have a ADA coordinator. So it will just depend how your agency want to implement your program. Some agency may have more than one, so they may have an ADA coordinator in each department or each division. Again, it's depending on your resources and how you guys run your program. But again, if you have 50 or more employees, you are required by law to designate at least one ADA coordinator for your agency. Okay, just like I mentioned before on the first bullet point, where sometimes the ADA coordinator do assist in coordinating any accommodation requests. But in some cases where I seen local agency, they delegate that task to the city clerk, and the city clerk normally will handle those services. So it all just depends how your agency handle any reasonable accommodation. Okay. Again, like I say, I seen agency that have a main ADA coordinator, and they have other designees that's under them for other departments. So it just depends how your agency want to handle the ADA program. Now, we often do get questions like, what happens if I have 50 or less employees? Is this still required to have an ADA coordinator? No, it is not required, but we highly encourage you to have a point of contact. It doesn't have to be a designated ADA coordinator, but a knowledge ADA coordinator can assist the public if they have any questions regarding discrimination on ADA. Okay. Now, there are many benefits in having a knowledge ADA coordinator. Even for a smaller agency of 15 or less, are required not to have one, we still encourage you all to have one, so that way the public will know who to contact. It also make it easy to identify someone to help them with any questions or comments about disability discrimination. Now, a knowledge ADA coordinator will also be able to effectively assist people with disability and their question as well. Okay. Now, the ADA coordinator play a very important role, a key role in your agency, ensuring that they're ADA compliant. So it's very, very important to remember that the ADA coordinator not only play a key role in your agency, but they also to ensure that the people with disability get able to have reasonable accommodation as well. Okay. All right, so as we move forward to slide number 9, okay, slide number 9 have grievance procedure, okay? Adopt and publish a procedure to resolving grievance under the Title II of the ADA. Now, the grievance procedure should include a description on how and where a complaint under Title II may file with the government entity, which is local public agencies such as yourself. A description of time frame and processes to be followed by the complaint and the government entity, which is the local public agency. Okay. All right, let's go ahead and move to slide number 10 is the continuation of grievance procedure. So the grievance procedure also, we need to have information on how to appeal on an adverse decision, and also statement on how long the complaint file will be retained. Okay, right below that, we also have a statement that states if a public entity has 50 or more employees, it is required to designate at least one responsible employee to coordinate the ADA compliance. Okay, so below that, we also providing some examples. So if you don't have a grievance procedure in place, or you need to update the one that you have now, we did provide some samples under the hyperlink, which is sample grievance procedure in PDF as well as Word document. So if you right click on that, it's going to bring you directly to the sample. So you're more than happy to use that. Okay, so let's go ahead and spend a little bit more time on the grievance procedure, what it is. Okay, now a grievance procedure provide the public who believe they have been discriminated against because of their disability, or others who believe they have been discriminated against because they either have a friend or family member with disability. So with the grievance procedure, it's just a formal process to make the complaint known. So that is the purpose also for the grievance procedure. You want to have a formal process how the public is going to file an ADA complaint. Okay. Now here at Caltrans, we have an ADA grievance procedure that we address access requests that pertain to Caltrans infrastructure, which is the physical structure such as sidewalk, curb ramp, signal, and etc. Now, requests that do not pertain to roadway under the Caltrans jurisdiction will be forwarded over to the appropriate local agency. So you will also be notified with a letter or or email, including the contact information for the responsible agency. So if the public, end up using Caltrans ADA grievance procedure, and then when it comes to the Caltrans Office of Civil Rights, when they determine the jurisdiction is with the local agency, we will forward that request over to the local agency. Also include you on the email as well. Okay, so that way, everybody will be in the loop regarding that complaint. Okay, now I can share you a little bit more information on Caltrans, the contact, how to file a complaint with the ADA infrastructure team. Slide number 31. So as we progress through the webinar, I can go ahead and share you those contact information. Okay, all right. So neither the Title II or its implemented regulation describe what ADA grieving procedure must have. However, the Department of Justice have developed a model grievance procedure. So like I mentioned earlier on the beginning of slide number 10, right below that, those two samples that we provided, those are samples coming from Department of Justice, which is DOJ. Those are their example. Okay, so if you don't have a grievance procedure in place, I would encourage you to use what DOJ have, and you'll be more than just change the name up to your agency, and you can use what they provided on slide number 10. Okay, now even though the Title II, the regulation doesn't really state what must be in a grievance procedure, but here at Caltrans Division of Local Assistant, we recommend our local agency to have these following in their grievance procedure. Okay, a description of procedure for submitting the grievances, the steps that would take by the local agency, okay, reasonable and specific time frame for review and resolution of the grievances, okay, a two-step review process that allow for appeal, okay, and record keeping for complaints submitted, and last but not least, documentation of step taking toward resolution. So these are the recommendations that Caltrans Division of Local Assistance we would like all of our local agency to have in their grievance procedure. What I just mentioned, a description of the procedure, the steps that will be taken by the local agency, reasonable and specific time frame, a two-step review process, record keeping complaint, and documentation of steps being taken to resolve that with grievances. Okay. All right, so as we move forward to slide number 11, okay, slide number 11, we have ADA complaint log, okay. A public entity, which is a local public agency shall keep on file for 1 year of all complaint of non-compliance received, okay. A record of such complaint, which may be a summary form, shall be kept for 5 years. Okay, so right below that, we have an image of a picture of ADA accessibility access. Okay, now to ensure that the ADA complaint log align with your grievance procedure or process, you want to ensure that on your complaint log, especially when it comes to the resolution date and when that grievance was completed, you want to ensure that if your grievance procedure is stating that you'll resolve that ADA complaint within 120 days, you want to ensure that whatever you log on to your complaint log, it matches or aligns with what you have on your ADA. Okay, we do find some instances where we see local agency, they have the grievance procedure. We're looking over their grievance procedure. They have like, we contact the complaint within 60 days. They'll go ahead and resolve this within 100 days time frame, whatever the case may be. But when we look at the complaint log, the date doesn't match up. So they have, 120 days that this complaint would be resolved or contact the complaint. But when we look at the complaint log, it looks like it was out 160 days. So you want to ensure that whatever you have on your ADA, on your grievance procedure, it does align with your ADA complaint log. Okay. If you don't, then you'll be out of compliance. So you want to make sure if you need to make extra time or add a little extra day or business days on top of your ADA grievance procedure to allow you guys to have more time to do the investigation, then I will go ahead and recommend that. But whatever you put in your ADA log, you want to ensure that it does align with your ADA, with your grievance procedure. Okay. All right. So I'll go ahead and the next slide will be Annette, will be slide number 12. So I'll go ahead and pass that to Annette, and she can go ahead and go over the poll question with you all. Annette?
Hi, thank you, Kathy. Just a reminder before the poll question, please submit your questions to the Q&A box, which is to the left of the chat box. We are not taking questions in the chat box. Okay, we have reached our first set of poll questions. Let's see how well we do with the following true and false questions. The first one, Section 504 of the Rehabilitation Act, which is similar to Title II, covers all programs receiving federal financial assistance and the operations of federal agencies. Is this A, true, or B, false? Okay, the answer is true. Section 504 of the Rehabilitation Act, which is similar to the Title II, covers all programs receiving federal financial assistance and the operations of federal executive agencies. We'll go to the next question. A public entity must designate at least one employee to coordinate ADA compliance if it has 10 or more employees. Is this A, true, or B, false? Okay, the answer is false. A public entity must assign at least one employee to coordinate ADA compliance if it has 50 or more employees. Smaller entities are encouraged but are not required to have an ADA coordinator. Then we'll move to the next true and false question. All public entities, no matter how many employees, must adopt a grievance procedure. Is this A, true, or B, false? Okay, the answer is false. Only entities with 50 or more employees are required to adopt a grievance procedure. Smaller entities are encouraged, but not required to adopt a grievance procedure. Please note, if a local agency receives an ADA complaint, the agency is encouraged to resolve local complaints at the local level. Great job, everyone. We will proceed to the next slide. Okay, we have reached our first Q&A session and we'll spend the next 5 minutes, of which Kathy and Daniel will respond to questions submitted in the Q&A box, which is located on the bottom panel. Kathy and Daniel, you may proceed.
All right, thank you, Annette. All right, Daniel, do you have any good questions or comments on the Q&A panel?
Yes, we do. Can you hear me okay, Kathy?
Yes, I hear you just fine.
Excellent. So yes, we have a few questions here that we can answer right now. The first, when is ADA triggered to be applied against existing facilities? Great question. ADA is always triggered. Each agency should have a self-evaluation plan to conform to the ADA compliance requirements. And again, if the agency is large enough, they will need to have 50 or more employees of the agency. They will need to actually have resolutions or plan resolutions for those existing facilities if they have 50 or more employees.
Yeah, just to add on what Daniel mentioned, as we progress through this training, we're also going to mention those as well for the existing facility, as well as what a transition plan is. So this will be the second half of our webinar regarding the question that you just stated, Daniel. So we can go ahead and address those two during the second half. But yes, you're right, Daniel.
Thanks for the clarification, Kathy. Yes. Second question, slide 7. Can an agency hire a consultant to act as the ADA 504 coordinator? Well, for continuity purposes, The Division of Local Assistance recommend the ADA coordinator is an agency employee. The Federal Highway Administration, who is the federal oversight agency for Caltrans highway projects, they only recommend contracts be extended as far as 5 years total. So for continuity purposes, we strongly recommend that the ADA coordinator is an agency employee.
Yes.
You have any comments, Kathy, to add?
Yes, so that's correct, Daniel. Just to add on that as well. Yeah, so a consultant cannot be the ADA coordinator for your agency. However, if you want to hire a consultant to perform your self-evaluation plan or transition plan, you can definitely do that. But he or she just cannot be the designated coordinator for your agency.
Thank you, Kathy.
You're welcome.
Third question. Can an agency have more than one ADA coordinator? Yes. Federal regulations require the appointment of at least one coordinator that works for the agency.
Good question, huh, Daniel, so far?
Yeah, these are great. Okay, question 4 here. What kind of experience and training is required for the employee assigned as the coordinator? And is there a continuing education training required to comply with the 504 coordinator requirements? Best practices dictate the coordinator should have familiarity with the agency requirements that are designated within Chapter 9 of the Local Assistance Procedures Manual and the federal regulations, including 28 CFR 45 and 49 CFR 27, along with the ADA planning needs of the agency. Do you have any other insight to provide, Kathy?
No, you perfectly worded great. Thank you, Daniel.
Yes. And then another question, does Caltrans have a sample complaint log? Kathy, are you familiar if we have a sample complaint log up on our website?
We don't have a sample of that, but we just got the grievance procedure, but we can definitely look into that. So I can go ahead and make a note. That we don't have. We can definitely go ahead and see if we can find a example of a complaint log and post to our divisional local assistant website.
Perfect. Thank you, Kathy.
And we can take one more question before we continue with the training. And if your questions have not been addressed, we will have more Q&A time throughout the training. Kathy and Daniel, you may proceed.
All right, one more questions.
So is the sample complaint log the same as a request log for ADA curb ramps? So the ADA curb ramp request may be a part of the sample complaint log where a resident within your agency's jurisdiction may request for an ADA curb ramp where there is not one in place already. However, the complaint log may go beyond that, including access to facilities, parking, etc. Did you have anything further to add, Kathy?
No, I mean, that's pretty much right. So if they receive an ADA complaint, if you have a grievance procedure, that person is responsible to handle, though they can determine, what jurisdiction or what ADA compliant it is. So with this one, it sounds like it will be an ADA request or maybe a request to install a curb ramp. Is that the question? Install a curb ramp or maybe a missing detectable warning, whatever the case may be?
Yes, it was just around the question was, is the complaint log the same as a request log for ADA ramps? So there is that difference, whereas the complaint log takes the entire universe of the ADA program, whereas the ADA ramps is a part of that program.
All right, welcome back, everyone. Let's go ahead and start the second half of our webinar. So we're moving forward to slide number 15. Slide number 15 is ADA policy statement. Provide information to the public and how it applies to the public entity, which is the local public agency. Put the notice on your public entity website. Include the notice in your social media account if you have one, such as Twitter or Facebook. Post a notice at a public facility, related to your ADA policy statement as well. So all that, there's different ways how you can post your policy statement. So we can go ahead and go that further as we progress to the next slide. Okay. All right. So slide number 16, which is the ADA continuation of the policy statement. You can also publish the notice on your local newspaper, broadcast the notice in the public service announcement on a local radio or television station. You can also include your notice in your program announcement and job application or employment application. Okay. Right below that, we have a note that states provided in alternative format so that it is accessible to people with hearing and vision disability. Okay. Right below that, we also have examples of a policy statement. So if your agency do not have an ADA policy statement, you can more than happy to use the one we provided right below that on bottom page 16. So you right click on that, it's going to bring you directly to the samples. So the sample is provided in PDF file, which is PDF Word document, and also in a Word document as well. So those is to ensure accessibility. So you can definitely use the one we provided below the slide number 16. Okay. So all local public agency must provide information to the public, program participant, program beneficiary, applicant, and employees about the ADA and how it applies to the local public agency. Okay. Now the ADA notice requirement applies to all state and government entity covered by the Title II, even when your local agency have fewer of 50 or more employees. Okay. So the ADA policy statement applies to all agencies, regardless of size. Okay. Now the three main consideration for providing notice is who is your target audience for the ADA notice? Okay. What information shall the notice be included? Where and how should the notice be provided? Okay. So to save you the trouble or, to reinvent the wheel, you can definitely use the one we provided on the samples called sample policy statement. The only thing when you use that, you want to ensure you change the name into your agency name and find ways how you're going to post those notices. Like we mentioned earlier, you can post it on any of your public facilities, such as your library, your city hall, like we mentioned earlier, by your local newspaper or maybe a program announcement. So whatever how your agency want to post the policy statement, it is required for you to have a policy statement. But depending on how you want to post it, that we leave that up to you or how you want to post a policy statement. You definitely want to post it where the public have access to your building, or even to like the library would definitely be a good example to post your ADA policy statement, or even like I mentioned, your city hall or your employee lounge area. So whatever case may be, you want to make sure you have that made available, not only to your employees, also to the public as well. Okay. Now the local public agency, which is yourself, that you must provide the information, not just once, but ongoing basis. Okay. So what I mean by that is that, if you have changes to your ADA, such as maybe you have a new ADA coordinator. Okay. So if you have a new ADA coordinator, then you want to update your policy. So that would be a good practice. So if you have ADA coordinator, a new ADA coordinator coming in, then you want to make sure you update the new ADA coordinator contact information on your ADA policy. Okay. So that's what I mean by that, where when you provide that information, you don't want to just provide it once. You want to make sure that is an ongoing basis. So anything changes to the ADA program, you want to make sure you update your policy statement as well, especially when they come to your ADA coordinator. If you have doing a transition or new employees, then that would be a perfect way for you to update your policy statement. Okay. Now example of alternative format. I mentioned that below where the notes say provide an alternative format. The few examples that you can do as your agency, you can provide closed caption to public servant announcement on television. You can offer large prints. You can offer Braille, Hotmail format on accessibility website, audio recording, or even radio announcements. So those are just a few examples of what an alternative format that you can provide for the public. Okay. All right. So let's move forward to slide number 17. Slide number 17 is self-evaluation plan. Okay. Now the self-evaluation plan is a critical area to evaluate as part of the self-evaluation plan. Shall accomplish by the following, but not limited to. Okay. Identify all programs, including public right-of-way facility, okay, such as your library, city hall, wherever the public have access to, okay, any activities and services under and their location, okay. So the self-evaluation plan, you also want to review the service, the activity, and program policy and procedure. So it is it's a government wide. So not, you just don't want to reveal your policy, your program policy or your procedure within a department. You want to make sure this is an overall on your statewide or countywide. So if you work for the city of let's say for example city of Sacramento, then when you do a salary evaluation plan, you're going to do it for the entire city, not just your division. Okay, so that's the purpose of the salary evaluation plan. You want to do the entire city. Okay, now with the self-evaluation plan, all local public agency, regardless of size, are required to ensure accessibility for individual with disability through the self-evaluation plan. So if you have less than 50 employees, you're still required to complete the self-evaluation plan. Okay, this does not apply regardless of size. The self-evaluation plan applies to all agencies, regardless of size. Okay. Now, we mentioned earlier that the self-evaluation is a comprehensive review of all programs, activities, and services in your agency. Okay. The goal of the self-evaluation plan is to identify not just within your department, but all policies, practices, and procedure in your agency. Okay. All right, so as we move forward to slide number 18, slide number 18 is a continuation of the self-evaluation plan, okay? So part of the plan, you need to survey your facility and determine whether there are physical barriers or access program, okay? So if it's non-structural change, you will include them in your self-evaluation plan. If a structural change are needed, then you include them in the transition plan. So we can go over with a transition plan as we move further, as we progress to this webinar. Okay. So right below that, I provided some hyperlinks. So one of them is how to develop an ADA self-evaluation plan and a transition plan. The second one is a survey form for the self-evaluation plan. Okay. So those are just example provided for you all as a best practice, or if you don't have a form in place, you can definitely use what we have. So those two hyperlinks are provided for future reference. Okay. So we're not going to click on that, but I just want to make sure that I have that available for you all. So in the future, if you want to use the samples that we have, you can more than happy to do that. Okay. So I know we also mentioned earlier at the beginning that all local public agencies, regardless of size, are required to have a self-evaluation plan. So that's what it is. That's what the note is stating, that regardless of size, all agency must have a self-evaluation plan. Okay. Now, the most commonly used method to conduct a self-evaluation plan is a field inspection or service method. Okay. So like I mentioned earlier, you can definitely use the form under the example that I provided on middle of page 18. You can use those forms as a survey method as well. But the most commonly used that we've seen for some of our local agencies, they conduct their self-evaluation plan by doing field inspection. Okay. Now we do often get questions from local agency that, well, Kathy, I have a self-evaluation plan. So when we look at the plan, we notice that the date is dated 1997, whatever the case may be. So even though you may have a self-evaluation plan, it is outdated. So especially when it's been, the law was passed in 1990. Okay. So when you have a self-evaluation plan that was completed in the 1990s, then you'll be out of compliant. The reason why you're out of compliant, because things have changed the past 10, 20 years. So when the last time you update your plan, it was in 1990, then you're in compliance. Again, so time has changed, facility have changed, programs, staff, even the ADA regulation have changed. Okay. When the ADA design standard came out in 1991, they also update that in 2010 as well. So if you have your evaluation plan back in 1990s, then your plan is outdated. Okay, the 2010 standard came into place around 2010. So with that in mind, a lot have changed. So that's why it's very important for you when you do a self-evaluation plan. You have to make sure, we recommend for you to update every three or 4 years. With a divisional local system, That's one of our recommendation. We encourage all local agency to update your plan every 3 or 5 years. Okay. Again, like I said, you might have a new ADA coordinator, you might have a updated grievance procedure, you might have a new facility, or maybe you got to make sure a new program had came to play. You want to make sure that program is accessible with people with disability. So a lot have changed. So you want to ensure that when you do update your plan, you want to update at 3 or 4 years. So that would go ahead and make sure that if any new program can come into place, you guys can ensure that that program or procedure, even the facility, is ADA accessible. Okay. Now, another way that for the salary evaluation plan is very important to seek input. Okay. Now, a local public agency shall provide an opportunity to interest person, include individual with disability or any organization representing individual with disability, to participate in your self-evaluation process by allowing them to submit for comments. Okay, so that's one of the major things with a self-evaluation plan. So when you create that plan and surveys in your department, you also want to go ahead and seek public input from the public as well, and allowing them to submit any comments. Okay, so that's something very important for you to have on your plan, to seek public input, is also to seek internal as well as external output. Okay, now with the department and program, one way to make sure that your self-evaluation plan is comprehensive is to identify your agency programs, services, and activity. So what I mean by that within an agency, or your agency may have 10 or 20 departments. So such as you may have a city clerk office, a human resources, library, a mayor or a manager office, park office, police, planning, public works, and etc. So again, you may have 10 or more departments within your agency. So you want to ensure that you also survey those departments as well as part of your self-evaluation plan. Okay. Now, as a local public agency, it is your goal to provide equal access to all persons with disability. Okay. Now, depending on your number of facilities, services, and public right-of-way for which you're the agency responsible for, and whatever resources available to you, some agency, I have seen it before, where they will contract out. They will contract and a consultant to come into their agency to assist them with the self-evaluation plan. Okay. Now it all just depends on your agency, what resources are available for them. So if you have those funding resources available to hire a consultant, then I would definitely encourage you to do that. Because the self-evaluation plan is not something you do overnight. It can take months or sometimes even years to complete, depending how big your agency is. Okay. If you have a smaller agency, of course I would encourage you to hire a consultant. But if you have the financial resources to do so, then yes, I will encourage you to do that. But if you're a small agency, I wouldn't recommend for do that. But bigger agency, I have seen they will hire consultant to come in to survey all their, not only within their department, but also for the surveys the public as well. Okay, so that's very important to remember that, even though I know there was a question earlier regarding, can a consultant be an ADA coordinator? They cannot be an ADA coordinator, but however, that ADA coordinator can hire a consultant to perform the self-evaluation plan. Okay, so once the consultant perform that plan, they can report to the designated ADA coordinator regarding those results. Okay, so you can definitely hire a consultant to perform these plan for you, but they just cannot be the designated ADA coordinator for your agency. Okay. All right, so let's go and move forward to slide number 19. Slide number 19 is a continuation of the self-evaluation plan. Okay, now this is definitely a requirement. Okay, so a local agency shall implement a system for reviewing and update the evaluation. Okay, now this is a requirement. So like I mentioned earlier, even though the self-evaluation plan, the regulation does not state how often you need to update your plan. With here at Caltrans Divisional Local Assistant, we recommend for you to update your plan every 3 years. Okay. However, on slide number 19, the regulation also state that you need to have a system in place to update the plan as well. It doesn't state that how often you need to update the plan, but the local agency will need to have a system in place on how you're going to update that plan. Okay, so the regulation is also provided right below that. Below the link is 49 CFR 27.11 is where you'll find the regulation for the reason why you had to update the self-evaluation plan. Okay, right below that. And below that, there's also an image of a picture of ideas of accessibility access, and as well as they have a little light bulb up there saying that they have some updates, or how they're gonna show to update their ADA accessibility. So that's an example of a picture right below that. Okay. All right. So again, with this, it is very essential. Okay. And it's also a requirement for you as an agency to have a system in place. I want to go ahead and make sure I stress that. The reason why I want to say that, because when we go out there to ask to see a local agency plan, we notice that their plan is outdated. And then our next question is asked, do you have a system in place? And they will respond, no. Okay, so by responding no, or you don't have a system in place, then you're not in compliance. Okay, it is required by the law to have a system in place, as stated on the 49 CFR's regulation. Okay. All right, so moving forward to slide number 20. Okay, slide number 20 is a transition plan. Okay, so now there's an image right below that is, what is a transition plan. It just states some of the in bullet points what we would like to see in a transition plan. Okay, now we also mentioned, the self-evaluation plan, and you need to have 50 or more employees. With a transition plan, this one you don't need. You have to have more than 50. I'm sorry, let me backtrack. The self-evaluation plan, regardless of size, all agency must have a self-evaluation plan. Okay. Now the transition plan, yes, 50 or more employees are required to develop the transition plan. So if your agency has 50 or more employees, then you are required to have a transition plan. Okay. So what is a transition plan? Okay. So in your transition plan, we would like to see identify physical obstacle in public agency, which is your agency facility, and that limit the accessibility of its program or activity to individual with disability. Okay. In your transition plan, you also want to describe in detail the method that will be used to make the facility accessible. Okay. All right. So let's move forward to slide number 21. So slide number 21 is a continuation of a transition plan. Okay. In your plan, you also want to make sure you specify the schedule for taking steps necessary to upgrade access to meet the ADA and Section 504 requirement in each year and the following the transition plan. Okay. And indicate the official responsible for implement of the plan, as well, including the curb ramp schedule. So if you're the ADA coordinator, if you're responsible to update your transition plan, then your contact information should be on the plan. However, if you have, if you're the ADA coordinator, but you have other tasks or other responsible employees that handle the transition plan, you want to ensure that their contact information is on that plan. Okay. And the reason for that is because if the public or anybody have questions related to the transition plan, they can contact he or her for any questions that they may have. Okay. Now, right below that, I have a note that states that transition plan is developed from self-evaluation plan or the facility survey. Okay. So after you conduct a self-evaluation plan, part 2, if you have 50 or more employees, is what we call the transition plan. Okay. So after, your survey, all your departments as well, you see feedback from the from the public, then you want to, after when you're done with that, you want to conduct this transition plan. Again, the transition plan only applies for agency that have 50 or more. Okay. So in the event that a structural change to a facility would be undertaken to achieve program accessibility, a public entity, just any agency or local government that employs 50 or more shall develop the transition plan. Okay. So I want to make sure I make that clear. Transition plan only applies to 50 or more employees. Okay. Same thing with the self-evaluation plan. You also want to seek input. Okay. So your agency shall provide an opportunity to the interest person, including individual with disability, or any organization representing individual with disability, to participate in the development of transition plan by allowing them to submit for comments. Okay. So same as with the self-evaluation plan, you want to seek input. The transition plan is the same process. So once you get the transition plans completed, you also want to go ahead and seek input as well, allowing individual with disability or anybody representing them, allow them to submit for any comments or feedback. Okay. Now, the self-evaluation plan and the transition plan must be included in the public involvement. So both are very similar. You know, again, one doesn't, regardless how many employees that you have, you still have to complete one, which is a self-evaluation plan. Transition plan, 50 or more employees. But regardless which route you go with, they both must involve the public involvement. Okay, that's very important to involve your public. You can't just complete the plan. Okay, we're done with the plan, but it doesn't stop there. You also have to seek input from the public once you complete the transition plan. Okay, you want to let the public know that the transition plan is completed. You can either make it available on your city website, or you can have a paper copy on your city hall, or maybe your library, or any places where the public have access to. So you want to ensure that they can go ahead and provide any feedback. So that's why I mentioned earlier, it's very important to also have the contact information, whoever is responsible for the transition plan, to have their contact number or the email information on that transition plan. So that way, if anyone want to contact, they have a point of contact for that plan. Okay. Now with the transition plan, it must also include, I know we mentioned this earlier as well, the curb ramp schedule. Okay, so the transition plan must also include a schedule for providing curb ramp, giving priority to walkway, serving entity covered by the ADA, including local government offices, facilities, transportations, places of public accommodation, employers, and followed by walkway, serving any other public areas. Okay, so you want to ensure that your transition plan also include curb ramp as well. That is part of the requirement as doing the transition plan. All right. Now the plan shall, at a minimum, should include the identify your physical obstacle. Okay, so in your agency, you want to ensure that you identify all your facilities that limit the accessibility of its program or activity to individual with disability. Okay. 2, you want to describe in detail the method that you will use to make the facility accessible. Okay. And 3, specify. So you want to specify the schedule for taking steps necessary to achieve compliance with this section and other, as well as time period of what the transition plan. If it's going to take longer than 1 year, then you want to go ahead and identify steps that would take during that year of the transition period. Okay, so that's very important to remember. This is just like a timeline. You want to specify the schedule that you'll be taking the necessary step. If it doesn't get accomplished within that year, what steps are you taking moving forward? Okay, and also 4, indicate. You want to, we mentioned that earlier as well, indicate the official responsible for implementing the plan. Okay, these are the top 4 requirements that division of local assistant we would like our local agency to have in the plan. To identify any physical obstacle in any of your facilities, describe in detail the method that would be used to make the facility accessible. 3, specify the schedule for taking necessary steps to achieve compliance. Okay, and 4, indicate the official responsible contact person that will be implemented the transition plan. Okay, so very important to include these 4 requirements in your transition plan. Okay, now with this in mind, one of the takeaway I will leave with you guys is that a transition plan is a plan that identifies physical barriers or any obstacle that limit accessibility. Okay. It also describes the method to be used to make the facility accessible. Okay. It also provides schedule for making the access, any modification, indicate any, also you want to indicate any schedule such as curb ramp schedule is very important to have. I have seen some cases where agency will have a transition plan and they also will have a curb ramp schedule plan. They will have two separate plans, which is fine. That's great. You can also include that as well. But to ensure that when you do have a transition plan, you may not have that as part of your transition. If you have two separate reports, that's fine. Again, we have seen some cases where agency put those in two separate plans. They have one for transition plan. They have another one for just curb ramp schedule. Okay, so just depending how your agency implement the ADA program, you want to ensure that you have some kind of curb ramp schedule included as part of your plan. Okay. All right. So we'll go ahead and move forward to slide number 22. We'll go ahead and have Annette take over this slide and she can go over the poll questions as well. Annette?
Hi, thank you, Kathy. And thank you all for submitting your questions. They're all important to us, but just to ensure that your questions are, noticed, please make sure you add them to the Q&A box, not the chat box. The Q&A box, which should be located toward the bottom of the screen to the left of the chat box, the Q&A box. Thank you. So now we've reached our second set of poll questions. Let's see how well we do with the following true and false questions. And this time I'll give you more time. I think I was kind of rushing through it earlier, so sorry about that. So we'll go to our first question. A public entity must develop a transition plan if it has 50 or more employees. Is this A, true or false? Looks like we don't have A's or B's here. So is this true or false? And I'll give you some time. Great. Wow. Most of you got it, 90% at true. Yes, the answer is true. A public entity must develop a transition plan if it has 50 or more employees. Smaller entities are encouraged, but not required to develop a transition plan. We'll move to the next question. All public entities, no matter how many employees, must conduct a self-evaluation. Is this true or false? Okay, the answer is true. True. All public entities, no matter how many employees, must conduct a self-evaluation. Great job, everyone. We will proceed to the next slide. Slide number 23. We've reached our second Q&A session, and we'll spend the next 5 minutes, of which Kathy and Daniel will respond to questions submitted in the Q&A box, which is located on the bottom panel. Kathy and Daniel, you may proceed.
Thank you, Annette. Oh, there's been so many good questions asked here. Unfortunately, we may not get to all of them today, but we will answer and post them up onto one of our websites. In fact, the Local Assistance ADA website, within a reasonable time frame here to make sure we answer everybody's question. First question, and we may not have the answer to this one today, and that's okay. We'll still get back to you and let you know. What is an excellent time frame to resolve the complaint logs? And this person inquired, for example, 120 days. And
from our perspective, it depends what the complaint is. If it's a barrier and it's not a high priority barrier on the agency's transition plan, it may well take longer than 120 days. However, if it's something simple such as removing a branch, then the expectation is that it moves up higher on the priority list and it's removed from the sidewalk accordingly. Kathy, did you have any further input on the resolution of the complaint log? Okay, Kathy may have stepped away for a moment.
Oh, I'm sorry, Daniel. Hi, I'm sorry. I was on mute. Yeah, so just like Daniel stated, it just depends. Documentation is very important to have. So if your agency have 120 days to resolve the ADA complaint, and let's say, for example, like Daniel mentioned, if it's a curb ramp, then of course that's going to take it longer than 120 days, depending how the resources you guys have available. But the important thing to remember on your log is to documentation. So if you don't have an example of a complaint log, you can put a comment section saying that you attempted to contact the person that's filed the complaint because this is a more of an in-depth ADA complaint. You want to make sure you note that. You may not resolve that in 120 days, but at least you would have that as a document. You want to make that documentation in your log. So yeah, I agree with you, Daniel. It just depends on what the grievances is. If it's something as simple as printing a large print for agency just to make it more visible for the other person, yeah, that can be something, a simple process can be done within a day. But something with a curb ramp, we can understand that it can take a while within 120 days. So the important thing is it's just documentation.
Thank you, Kathy.
Okay.
Next question, please clarify which requirements apply to employees versus which apply to the public agency serves, or does it apply to both? Well, all ADA requirements apply to both employees and the public. If we recall, the ADA program provides equal participation to all individuals, so that includes both public and employees. Next question. With more people working from home, would the 50 or more rule still apply? I assume that's in relation to the number of employees total that work for the agency. That answer is yes, especially since there is little to no restriction for the public to use agency-owned facilities. And there was a really good question here. I'm going to be skipping down a little bit, and I wanted to take some time to address this one, because this one has actually occurred here in the city of Sacramento. And the question says, property owners are responsible for the maintenance of sidewalks. How do other jurisdictions handle responding to ADA requests for barriers in the right-of-way when the property owner is responsible for maintenance? And California legislation authorizes cities to make the determination if landowners or the city will be responsible to maintain the sidewalk. For example, in the city of Sacramento, property owners are responsible to maintain the sidewalk, but the city does have the right-of-way to enter. So for example, the city receives a complaint of a broken sidewalk caused by a tree uprooting the concrete, which then places the sidewalk out of ADA compliance. So the city will receive a ticket or a notification in their complaint log. We have a nice little notification system here called Sacramento 311. And a ticket will be generated and the city will inspect the sidewalk and draft an invoice estimate and provide that to the landowner to have the city perform the maintenance. As a policy, the city will also inspect within a radius of 75 feet from the complaint to make sure that there are no other visible barriers within the stated area of complaint. So again, excellent question. Did you have anything else to add, Kathy?
No, you responded perfectly.
And
Okay.
And we can take one more question before we continue with the training. And if your questions have not been addressed, we will have another Q&A during this training. Kathy, Daniel, you can take one more.
Okay.
Yes, thank you. So this one's came up a couple of times, maybe in a couple different methods. Our agency ADA transition plan and self-evaluation plans are from many years ago. Neither have been updated in many years. What is the requirement to maintain / reevaluate these plans? Well, there is no requirement other than just periodic updates. As a best practice, the Division of Local Assistance recommends updating the self-evaluation every 3 years, which would in fact coincide with the update to the agency's Transportation Improvement Program. So therefore, you've captured what the agency's needs and priorities are, and then you're transitioning from the self-evaluation plan to get them programmed within that agency's TIP. And the transition plan is recommended for updates every 3 to 5 years following the adoption of the self-evaluation. So you have the self-evaluation plan, which identifies the needs, priorities, feasibility, and timeline of implementing barriers to the ADA, barriers for individuals with disabilities. And then with the Transportation Improvement Program, you're then funding and programming those remediations into that document or report. Anything else to add, Kathy?
No, sounds good, Daniel. Thank you.
All right, we're going to transition back over to Kathy. Take it away. Thank you.
All right. Thank you, everyone. Thank you for submitting those questions. And as Annette mentioned, we do have another Q&A session as well. One more toward the end of the presentation. So we'll go ahead and address those as best as we can. If we're unable to address those, we'll go ahead and also develop what we call a Q&A documentation, where we'll make that available hopefully in the next couple of weeks. We'll put that on our Caltrans Division Local Assistant ADA website. So we'll make sure those are made available for you guys as well. Okay. All right. So moving forward to slide number 24. Okay. Communication. Okay. So agency also is required to have a communication in place for ADA as well. Okay. Process for requesting auxiliary aid and notification and procedure to obtain those requests as well. Okay. An accessible website is very also important to have. Okay. Effective communication with individual with hearing difficulty. Okay. So let's going to spend a little bit more time on this slide number 24. Okay. Now, many people with disability are prevented from participate fully in programs, activities, and service because of communication difficulty. Okay. Now, to address this, the ADA, which is the American Disabilities Act, require that communication with people with disability must be effective as people have communication with others. Okay. Now, under the Title II of the ADA, all state and local government are required to take steps to ensure that their communication with people with disability are as effective as with others. Okay. That's very important to remember, that even though, you know, we sometimes we do take it for granted that, you know, it works as fine, but we also got to ensure that when we have those the effective communication, we want to make sure we include the individual with disability as well. Okay. Now, the ADA coordinator or even the city clerk is often the main contact when someone wishes to request for accommodation services for effective communication. So depending on your agency, again, like, you know, every agency works a little bit different. But in our case, we see some agency where the city clerk is a point of contact for any request for a special accommodation, okay, such as sign language interpreter or even document that they want in Braille. So either the city clerk or even the ADA coordinator is the contact person to request for those accommodations. Okay. Now, some samples that I can provide for you, you know, for people who are deaf or hearing loss. You can offer interpreter on site or through a video remote. Okay. You can also offer real-time computer aid, which is transcription service. It's called CART, C-A-R-T. You can offer that as well. You can offer like written material, okay, exchange of written notes, assisting listening device, and open and closed caption, including real-time captioning. Okay, so these are some example for people who are deaf or have hearing loss. You can offer some of these services. Okay, Now, the other service you can offer for blind or people who have a visual disability, you can offer them like large print material, audio recording, braille material, screen reader software, note taking, or qualified readers. Okay. Now, for people who have speech disability, you can offer exchange of written notes or type communication. A person trained to recognize unclear speech and repeat it clearly. So these are some of the accommodation that you can offer the public if one is requesting to have a service in a city or a county that you guys are in. Okay. Now, I also mentioned that accessibility website. Okay, why should a website be accessible? Okay, now the internet have dramatically changed the way state or any local government do business. Okay, so as a result, many people can easily access information 7 days a week, 24 hours a day. Okay, so making a website accessible means you want to simply follow the relatively simple steps. Okay, now we do notice that in some state and local government, they will often post documents on their website using what they call the portable document format, which is called PDF. But most PDF documents or those in other images based format are often not accessible to blind individual or who use screen readers, or with low vision who use text enlargement program or different color or font size to read the computer display. Okay, so for example, here at Caltrans Division of Local Assistant, we have a team that whatever we post on our internet, they will ensure that our PDF files are ADA accessible. Okay, so before, for example, with this presentation that you're seeing here today, this will be made also available in our Division Local Assistant ADA website. So before we post this on our website, it goes to our IT team, and where they would go ahead and ensure that PDF is ADA accessible before posting onto our internet. Okay, so it's very important that when you do post any public document, that public document is also ADA accessible. Okay, so that's one example that we have here at Caltrans. We have a team that anything that we post online, they want to ensure that that's ADA accessible as well. If it's not, then they can't post that on our internet. Okay, so that's something to keep in mind as well. Okay, all right, so moving forward to slide number 25. Slide number 25 is the ADA annual certification form. Okay, and right below that on page 25, that is where you'll find the form as well, the LAPM chapter 9, section 9.2 accessibility. So you also will find the ADA program under that as well as a form. Okay, now the local public agency must provide Caltrans District Local Assistant Engineer, which is the DLAE, with a completed Exhibit 9C, the local agency ADA annual certification form, by June 3rd every year. Okay, now Exhibit 9C include, who is the designated ADA coordinator. If it applies, if you have 50 or more employees, then you would just put NA on that form. This is because it's not required for agencies with 50 or less employees. In that form, the Exhibit 9C is going to ask you your salary evaluation plan. When was it completed? And if it's not completed, when is the date of a completion date? Okay, it's going to ask you. It's also going to ask you about transition plan. If you have 50 or more employees, if you have less than 50 or more employees, you can also put NA on that response as well. Then it's going to ask you if you have a grievance procedure. So all this on that form, it's just to see what your agency have. And if you don't have it, let's say if you have your plan is out of date more than 3 or 4 years, then in some cases the district office, which is we have 12 districts within California. So your district office would notify us, the headquarters here in Sacramento, will let us know that it looks like so-and-so agency, the last time they updated the plan was back in 1995, whatever case may be. So that would flag us at headquarters to perform what we call either a desk or on-site program review of your agency. It doesn't necessarily mean it is a bad thing. It just means that that agency need more technical assistance, or more need a training, or training opportunity for us to go out there, or maybe we can do over the phone, whatever the case may be. So again, it doesn't necessarily mean that when we get a call from us, it doesn't mean that it's, we got you, you're not in compliance, this is what's going to happen. This form is just to help us to offer that technical assistance if needed. Okay. Although the form on the ADA annual certificate form state that you will only need to complete this form if you're receiving federal financial assistance or you're receiving any federal aid project, we do encourage all local public agencies to complete the form as best practice, as this will assist us, divisional local assistant, to provide that technical assistance if needed. Okay, so the form, although if you right click on that exhibit 9C, the form is going to state you complete this form if you're receiving any federal funding. Okay, but here at divisional local assistant, we encourage you all to complete this form, because that form is going to help us to find out where you're at, what kind of technical assistance, what kind of training opportunity that we can offer for you guys, so that way we can either go out there to assist you guys or go out there to maybe do what we call a desk audit, whatever the case may be. So it doesn't mean it's, again, I always want to stress this to all the local agencies, that when we do perform any desk review or any desk audit or on-site audit, it doesn't necessarily mean it's a bad thing. It just means that we're out there to help you guys, to partner with you all to make sure you guys are in compliance. If not, then that's what we're here for. We're here to offer those resources for you all. Okay, now the perfect example would be this training that you guys that we're offering here today. The purpose of this training is from all the some of the ADA desk assessment that we have completed the last couple of years, that we have determined to find out that we do need to develop some kind of training to assist our local agency. So when we perform the desk assessment or either on-site perform a review, we've determined that that's why these local agency training is so important, because we want to get the word out. We want to get the ADA awareness out that, you're not alone. So if you're not in compliance, it's okay. We're here to assist you, Daniel, myself, and Annette, as well as we do have a guest speaker later on. We can go and introduce him later, but we're all here to help, to assist you guys to ensure that you guys are in compliance. Again, so when you do get a call from Caltrans or from headquarters, it doesn't mean it's a bad thing. It's actually a great thing to get a call from us, because we're here to assist you guys. Okay, just want to make sure I make that clear. All right, so so moving forward to slide number 26. Okay, slide number 26. We also have the ADA design standard. Okay, so we have 2010 ADA standard. Okay, local agency, regardless of whether they receive federal financial assistance, all required to comply with the federal. Okay, and below that, we also have the local assistance procedure manual, chapter 11, design guidance. Okay, this one provide statewide design guidance to local agency administrative federal aid transportation project. Okay, so I have a very important note at the bottom where it states that local agency do have an option to adopt for any of the other available federal standard, such as PRORAG, which is the Public Right-of-Way Accessibility Guidance. You have the ADAG, which is the ADA Accessible Guidance. You have the Uniform Federal Accessibility Guidance, okay, and also Title 24, California Building Code Standard, okay, whichever standard that you use, you want to make sure that they provide the greatest access to people with disability. Okay, now with that in mind, we also do often get questions and comments about, is my building grandfathered in under the older 1991 ADA standard for accessibility design, or do I need to comply with 2010 ADA standards? Okay, I'm going to read that questions. Okay, we do get these questions often. So is my building grandfathered in under the older 1991 ADA standard for accessibility design, or do I need to comply with 2010 ADA standard? Okay, now the ADA does not have a provision to grandfather a facility or existing facility, but it does have a provision called safe harbor, okay, in the 2010 ADA regulation for businesses and state and local government. Okay, so a safe harbor means that you do not have to make any modification to an element in a building that comply with a 1991 ADA standard. even if the 2010 ADA standard have different requirement for them. Okay, that's very important to remember. Unless those elements are altered on or after March 15, 2012. So even though the safe harbor means that you do not need to make any modification element to that building that comply with 1991 ADA standard. However, if you make any modification after March 15 of 2010, then yes, you will need to comply with the 2010 ADA standard. Okay. Now, please do note that the safe harbor does not apply to elements that were not addressed in the original 1991 ADA standard, but are addressed in the 2010 ADA standards. Okay. So very important to remember. It does not apply to elements that were not addressed in the original, which is the 1991 ADA standard, but now are addressed in the 2010 ADA standard. Okay. Very important to remember. All right. So we'll go ahead and move forward to slide number 27, which is ADA design standard. As best practice, we have what we call Caltrans Design Information Bulletin, which is the DIB 8206. This is an accessible design guidance to be consistent with current federal and state regulation. Okay, and to your right, we have an image of a copy of a Caltrans DIB, which is the California Design Information Bulletin. Okay, now the DIB incorporate design standard from the 2010 standard, as well as California Building Code and ProReg are above and beyond the 2010. So that's what the DIB is. So this is something that Caltrans has developed. Okay, now plus they also specify that it applies to Caltrans right away. While the local agency may adopt it, but we realize that it's more conservative for 2010 standard, and it may cost local agency more to implement this standard. So that's why this is just as a best practice. If you don't have a design standard in your agency, you can definitely use what Caltrans have, which is the DIB 8206, but it's just as best practice. It's not a requirement. Okay. Now we do have a guest speaker, Anthony Nang. He is from the Caltrans Office of ADA Project Delivery Team. So he will spend at least the next 10 minutes on the next slide to go over what's in the DIB standard. So he can go over that for you as in further detail. Now, just as a reminder, okay, if you have any questions and comments, please do type and submit the question in the Q&A panel. Now, if we do not address your question immediately, we do have one more Q&A that we do plan to address those questions. If not, then we'll go ahead and get that posted on the website. Okay. All right. So Anthony, our guest speaker. Go ahead, Anthony.
All right. Yeah. Thanks, Kathy. And yeah, welcome everybody. Yeah, over the next few minutes, we'd just like to go over real quick, like Kathy was talking about, the Design Information Bulletin 82 from Caltrans. So the DIB 82, this is a picture of what the DIB looks like. And as Kathy mentioned, the DIB stands for Design Information Bulletin. And so the significance of the numbers is the 82 means this is the 82nd Design Information Bulletin Caltrans has released. And what's even more important is the 06, which means it's the 6th version. So over the years, since we've actually started doing ADA, as many of you guys have been doing since 1990s, we've been updating our standards to trying to keep current with the current standards, and also to incorporate standards that's more practical, because there are, as Kathy has mentioned, there's a lot of different guidance out there, and there are differences between the guidance. So what we did with this DIB is we actually picked and choose which standards we actually wanted to incorporate as far as Caltrans standards. So once again, as Kathy has mentioned, one standard that we've used is the 2010 ADA Department standards. Another standard that we've incorporated is Title 24, which is the California Title 24 of the California Building Code, and also ProWag, which is a Public Right-of-Way Access Guide. So, in addition to these standards, there is UFIS, which is Uniform Federal Accessibility Standards, and also ADAG, which is the ADA accessibility guide. So these are two standards, federal standards that we have not incorporated into Caltrans standards or in the DIB because we decided the other three had more standards that we felt that were more applicable to Caltrans. And just for your information, for a lot of local agencies, that ADAC actually has been replaced by the 2010 ADA Justice Department standards. So with that said, just like what Kathy was just mentioning too, is that every local agency or public agency is required to adopt a standard. So any one of these standards that we just went over in these last few slides or last couple of slides, any agency can adopt either one or more of any of these standards, but each agency has to adopt at least one. But what you can do is you could do what Caltrans has done is do, pick and choose what you want. But if you do pick and choose, you have to create a document or actually list out exactly which ones that you are picking and choosing. So, but if you adopt, let's say, ProWAG and UFIS together, then in its entirety, then you are required to follow the more stricter of any one standard of the two. So that's why it's not recommended to adopt any like too many different standards all at the same time, because it does make it complicated. It definitely makes it harder for you guys to enforce. So, but like Kathy was saying, definitely you can use Caltrans, the DIB, but you just have to formally adopt the DIB as your official guidance or ADA guidance for your jurisdiction. And just to give you guys a flavor of, why we picked and choose and, what some of the, complexities could happen if you do adopt different standards, especially in its entirety, is that, for example, let's say clear width. From ProWAG, the minimum clear width is 48 inches, whereas in UFIS, it's 36 inches. So as we just mentioned, Caltrans, we've adopted ProWAG as far as clear width. So we've actually adopted a more conservative standard of 48 inches. And what's even more important is that for some of you guys who've been dealing with ADA, you guys know that ProWAG has been in draft form for who knows how long. And there is no set date on when they're going to approve final ProWAG. So right now, because if you look at ProWAG, it stands for Public Right-of-Way Access Guide. So since there's no official approval for ProWAG right now, it's only a guide. So it's definitely makes it harder to enforce because it's just guidance that's in it. But what we once again have done in Caltrans, we have officially adopted a certain parts of ProWAG. So now it is actually a part of our standards. So one really good example of why we officially adopted certain parts of ProWAG is running slope for curb ramps. So for many of you who have been involved with ADA, you guys know that the maximum ramp slope is 8.33%. But in one of the current drafts of ProWAG, it does say that in certain conditions or situations, you can actually exceed 8.33% as long as the running slope of your curb ramp is at least 15 feet. So if you dealt with Caltrans, you know that in our standard plans that our standard plan says 7.5% maximum for roadway for curb ramp slope. So let's say if you have a roadway that's at 5%, that means that the length of your ramp would be 28 feet if you use that 7.5% slope maximum slope for your ramp, which means it's going to be a really long curb ramp of 28 feet, which is pretty long, right? So, but if you go to the federal standard, which is 8.3%, you still end up with a 20-foot length of a curb ramp, which is still fairly long. So that's why we've adopted it to where we've adopted the ProWAG standard to where if we just keep it at 15 feet, the slope of your curb ramp could be whatever it is. And in this instance, it's 9.6%. And I've actually seen some designs where they've gone to like 11, 12, 13% slope. And that's totally 100% ADA acceptable. And now since we've adopted this one passage from ProWAG. Another thing that we've adopted is a cross slope. So most of us, if we know that the maximum cross slope for any ADA facility is 2%, but in the draft ProWAG, they actually say that if you have a situation that's without a yield or stop control, the cross slope can actually go up to 5%. So once again, this is one thing that we've adopted as well. So this is written in legalese. So it says without yield or stop. So what does that mean? So what it actually means is if you have something like here, like for us, a state highway, if you have a signalized intersection, which is not a stop or yield, the cross slopes of our crosswalks and our curb ramps could be up to 5%. But if it is stop or yield, then we are still limited to 2%. But then once again, if you look here, if it's not controlled, especially, and it sounds odd to say non-controlled, but this usually happens when we have a state highway that goes through a residential area. The state highway doesn't stop, but the residential streets or cross streets, they have stop signs. So in these uncontrolled intersections, we can actually go up to 5% cross slope as well. Then, and also another portion of draft pro ag, they even said under other certain conditions where you don't have a stop or yield, the cross slope can actually equal the street or roadway grade, which means that if you have a certain situation, which is outlined in our DIB, because if your cross slope or the roadway slope is at 6%, the cross slope of your curb ramp and crosswalk can actually also be 6% as well. So this is why, like we were saying, we've been updating even to our current 6th version of our DIB, because we want to incorporate the latest and greatest standards that actually helps us do what we need to do to be ADA compliant. Another the thing that we've adopted is the section on grades. And I think there was a question as far as what type of work is required to be fixed for ADA projects. So for Caltrans, it says for the grades, it says that if the roadway is contained within a street or highway right of way, then technically the grade of your sidewalk or your pedestrian access route can actually be the same grade as the roadway itself. But if you have those walkways that goes into, let's say, like a restaurant or a building, then that's not contained within the street or highway grade, then the maximum walkway slope can't be more than 5%. So why this is important is because when we have certain situations like this where we have an undercrossing, a lot of times we'll have to do a separate walkway with the old standards to keep that grade from being over 5%. But with this new standard, we actually don't need to actually provide this extra walkway, and we actually just have our sidewalk. So definitely saves us a lot of headache and heartache. And as Kathy mentioned earlier, we have a and the maximum flare slope can't be more than 10%. Maximum cross slope can't be more than 2%. And the maximum joining slopes can't be more than 5%, which is the walkway grades that we talked about. So if you look at this list, there's one thing that I'm sure a lot of you guys are noticing that's missing here, which is detectable mooring surface. So in the 1990s, the federal government, they did, at one point, they did have detectable mooring surfaces or the yellow truncated domes that other people are also known as yellow truncated domes. At one point in time, the federal government wasn't quite sure about the effectiveness of those. So they actually took out the requirement. So in a lot of these standards, older curb ramps, they do not have detectable mooring surfaces. So if you do have a curb ramp, let's say, that qualifies for safe harbor, only requirement is to add the detectable mooring surfaces, and as long as it meets those other requirements as well. Now, as far as clear width, let's say, which mainly applies for like sidewalks and walkways, once again, the standard for that is 36-inch minimum. If you do have anything less than 48 inches, then you do need a passing space of 6 by 6 inches or 5 by 5 feet in intervals of no more than 200 feet. And I think someone did actually ask a question about, can you reduce a walkway to 32 inches? And yes, at pinch points, you can actually reduce have a reduced clear width of 32 inches, but that pinch point cannot be longer than 24 inches. So if you have a situation like that, then definitely that can be considered ADA compliant. And there was another question, and I'm glad this person asked, is when would ADA requirements be triggered? So in the Department of Justice and Federal Highway Administration, FHWA, they actually have put out a memo to state that alterations would be considered well, let me take a step back. If you do have a project that requires an alteration, then you would be required to perform ADA upgrades. So what's an alteration? So in general, it means what they're trying to say is that if you're doing any type of resurfacing on your project, then that's considered alteration. And once it's considered alteration, then you need to upgrade all the ADA facilities, namely really just curb ramps. And resurfacing technically means just overlay of additional material, whether or not you're actually grinding out any existing material. So as long as you're adding any type of pavement, then you just consider it resurfacing. So here's a list of all the different types of projects or type of work that would be considered alterations. We're not going to go over each one in detail because each one has a story in itself. But overall, if you're doing any type of pavement work, even if it has a grain of sand in it, technically it's considered an alteration. So then there's a difference between alteration and maintenance work, because especially in Caltrans, we call our overlay projects maintenance work. And I think some of your jurisdictions might say the same thing too. But in Department of Justice and Federal Highways Administration, in that memo, they do make that distinction, saying that this list of work or these types of work would be considered maintenance type work, not an alteration. You'll see here they do have like painting and striping, chip seals, joint repairs, joint cracks. So if you're just doing these type of work, it's not considered alteration, and you would not have to upgrade the curb ramps. But one confusing thing in this memo that Department of Justice, DOJ, and Federal Highway Administration, FHWA, has included in their memo, is they say that any combination of several maintenance treatments can actually qualify as an alteration and trigger the obligation to provide curb ramps. So I don't know about you guys. I know when I first read this, I'm like saying, well, this is kind of messed up because you just gave us a list of what's alterations and what's maintenance work. So now you're saying, well, if I do different types of maintenance work, like let's say if I'm painting and doing joint repair, does that trigger it to be an alteration? Not necessarily. So, and it's not as sinister as it sounds and not as confusing as they're trying to make it sound. So, because what it is if you look at certain types of work that's considered maintenance, let's say like chip seal, like let's say if you do a chip seal, then you follow up with a slurry seal right afterwards in the same project, that's actually really a cape seal. And if you look back at the list of alterations, cape seals is listed as a type of alteration. So what they mean by that clarification is that, we just need to be careful because certain types of maintenance type projects is actually considered actually an alteration. And unfortunately, they didn't want to list all the different combinations, but at the very least, that's one prime example of what's considered an alteration. So, and the question is, if you guys do have an alteration, well, what do you have to do? So as far as curb ramps, it says that if you have existing curb ramps that are non-standard or non-ADA compliant, then you have to upgrade those to current standards. And if there's missing curb ramps or curb ramps where you have sidewalks that just end in a intersection in a curb return, but no curb ramps, then you have to add those curb ramps in. Now, as far as crosswalks, so in Caltrans, we call our, like we were saying, maintenance work, but it's really alteration type work. That maintenance to Caltrans definition. But in the federal definition, what we call 2R and 3R work, and 2R is roadway rehabilitation projects, and 3Rs is roadway rehabilitation and removal and replace of pavement. So if you have those type of work where you're actually removing some of the pavement and replacing it, then you have to upgrade the grade to be no more than 5%, as we saw in the standards earlier. But if you do have a total pavement reconstruction, we're actually removing the pavement, removing the base, and changing the elevation, all that stuff of your pavement, you're required to fix the cross slope to be no more than 2%, and the grade to be no more than 5% as well. So that's all we wanted to go over, because we don't want to, the DIB 82 is a whole document and a whole discussion in itself. But definitely, we're more than happy to answer any questions that you guys may have in regards to DIB 82. And definitely, if you guys do want to have any questions in the future, definitely feel free to send it to Kathy, and she will definitely forward to me. I'll be more than happy to answer. All right, so Kathy, I'll hand it back over to you. And
okay, thank
yeah.
you. You're going to stop sharing your screen, and I'll go ahead and share my screen. All right. Okay, thank you. All right, do you see my screen, Anthony?
Yes, I do.
All right, thank you, Anthony. Okay, so yeah, that was a lot of information. But again, if you guys have any questions related to Anthony presentation, definitely go ahead and submit your question in the Q&A panel. Or you can, if you have something you want to talk offline, you can reach out to me. I can forward that information over to you with Anthony contact information. I can do that as well. All right, so moving forward to slide number 29, I'll go ahead and hand it over to Annette. And Annette?
Thank you, Kathy. We have reached our final poll question. Let's see how well we do with the following true and false question. Local agencies do not have an option to adopt from any of the other available federal standards, whichever provides the greatest access. Is this true or is this false? Okay, the answer is false. Local agencies do have an option to adopt from any of the other available federal standards, whichever provides the greatest access. Great job, everyone. We will proceed to the next slide. Slide number 30. We have reached our third and final Q&A session, of which Kathy and Daniel will respond to questions submitted in the Q&A box, and will also open up the floor for verbal questions. Please use the raised hand icon to be selected for verbal questions so that Kathy, Daniel, or Anthony may respond. Thank you.
Thank you, Annette. Okay, so it looks like we do have plenty of time. It's about 11:04, so we can spend a little more time on this Q&A session. If anyone have any questions, we can go ahead and address those in the Q&A, and also open up the floor. Daniel, do you want to open up the floor for questions first, or do the Q&A panel first? How do you want to handle that?
Yeah, why don't we do a couple of the questions that have been asked in the Q&A panel, and then we'll transition over to see if there are any other additional questions.
Okay, sounds good. Yeah, just to let you know, Daniel, we have plenty of time, so we can take our time on this Q&A session if needed.
Oh, excellent. Thank you, Kathy.
All right, go ahead.
So the first is, does the transition plan require for an agency having more than 50 employees? Does this include full-time only, including admin, engineers, et cetera? So this covers all employees who work for the agency, including, if it's a municipality, fire, police, utilities, administration, transportation, et cetera, whether full-time or not. It's just, are they classified as an employee of the agency? Here's another good question. Is it valid to have all curb ramps, sidewalks in the public right-of-way be categorized as non-compliant to streamline the process of creating a schedule? Well, if the ramps are compliant, they wouldn't necessarily be included in the same priority where there are barriers to ADA compliance. So we want to make sure that, the self-evaluation plan prioritizes the for to the ADA program, and then they're addressed appropriately within the time frame according to feasibility within the transition plan. So therefore, a ramp with a major barrier in a sidewalk for public rights-of-way accessibility is going to be a much higher priority than one that was recently completed and, you know, may not have or require any maintenance for quite a few years.
Daniel,
Anthony.
Daniel, are there any questions that questions for Anthony?
Yes, I was just about to get to the man of the hour.
Yes, I'm scrolling through the questions. Yeah, there's one which is actually a very good question. It says, what is the reason for the delay of PROAG adoption? And you know, the maximum of 8.33% slope for curb ramp, or can you go just 15 feet and be whatever it is? So it's because of these type of things that there's still a lot of debates. So last I heard when I talked to one of the representatives from PROAG, it's about 85, 90% approved, like, because they're going, you know, standard by standard. And once they get it approved, then that's done. But then there's still others that are still being debated or contested. So that's why the overall PROAG is not adopted yet. So, but that's why Caltrans, we've been in close coordination with the PROAG people at PROAG. So that's why some of the ones that has officially been okayed but not officially published, we've adopted those as well. Let me see. So there's another question in regards to construction documentation. So does local assistance expect to see for curb ramp ADA compliance? And this person is knowledgeable in Caltrans forms because this person called out the CAM 5773 forms, which are stricter than the DIB 8206 forms. So Kathy, correct me if I'm wrong, but I do not, I'm not aware that these checklists will be a requirement for local assistance projects or even our permit projects too. So if you guys are doing a project that runs through Caltrans right away and you guys have to go through a permit with us, you guys are not required to fill out this form. And this form is actually literally a checklist that goes over each and every feature of curb ramps, sidewalks, driveways, and where you list off all the measurements and you have to measure each feature 3 times and document everything that's being done. That's only if you're in a Caltrans project or performing, you know, doing a Caltrans project. And the reason why this person says that our standards are stricter is true, because if you guys have looked at our current standard plans, let's say, for example, a curb ramp, the ramp portion of it, like we're saying, the federal standard is 8.33% max, and in our standard plans it says 7.5%, and that's just a Caltrans conservative standard, because one thing, and I'm an engineer, so I'm gonna you know, give us engineer a hard time. So we're engineers for a reason, because we like numbers. We do not like to read. So with that said, if you look at the standards, the maximum slope is 8.33% max. So when designers see the standard, they just focus on the number 8.33. They do not look at the word max. So they always design to 8.33%. Sometimes it goes over 8.33%, and if it does, then technically it's not ADA compliant. So that's why Caltrans has artificially lowered our standard to make it more conservative to 7.5%. But the thing is if it does get built and ends up being 7.9%, it's still below the federal standard and we're okay. So that's why Caltrans has artificially lowered our standards. But you guys do not have to follow that. Technically, if you guys adopt DIB 82, that closely mirrors federal standards, or actually it is the federal standards, just different parts of different standards, then that would be the guidance that would be more applicable to you folks.
Okay.
Then there's another question or asking for clarification. So it says, so if an intersection has a signal light, the maximum cross slope is 5%, question mark, and answer is yes, but that is from the proposed ProWAG standards. So so the key thing is, like we were mentioning before, is you need to double check with your agency to see what your agency has officially adopted as your standards. So, and whatever your agency has adopted, you have to follow that. So this 5% cross slope is from the draft ProWAG, which Caltrans has officially adopted. So we can use that. And if your agency has adopted ProWAG, and especially that portion of that section of ProWAG, then yes, you can. But otherwise, you might still be stuck with the 2%. Then there's another question, says, can we use the California MUTCD, which is a Manual of Uniform Traffic Control Devices, for the general placement of pedestrian push buttons, or is there a better design or standard practice? Yes, the California MUTCD is the guidance that Caltrans actually is using, and Caltrans has actually developed with folks at MUTCD to develop the California MUTCD, which is very specific for California, because all the other 49 states are using just the MUTCD. So yes, the California MUTCD is probably the best. Well, I would say is probably the best. Is the best guidance to use for placement of pedestrian push buttons. So okay, so here's another question. In new construction, does DIB 8206 permit slopes that do not comply with the 2010 ADA standards? The answer is yes. And the question is, under what authority? And as we mentioned, that yes, for the grades, the slopes, we've adopted the portion of the ProWAG, which allows the sidewalk, as long as it's next to the roadway prism, or as part of the roadway prism, the sidewalk slope, running slope, can actually meet the roadway grade. So if you're somewhere like in San Francisco, let's say, and you're on Lombard Road, which is the world's steepest road, right? I'm not sure how many percent that is, then the sidewalk would be ADA compliant if it just follows roadway. So if the Lombard Road is at 15%, the sidewalk slope can be 15%. That's mainly only, once again, because Caltrans has adopted that section of the ProWAG. So I see there's a person who raised their hand. Would you like to ask a question?
Looks like Sherry may need to unmute him or her.
Go ahead, David.
Okay, well, while David, so there's another person. Who's the other person? David Morey. No, okay. Well, while we're working it out, I'll read another question in the Q&A. So do alterations to roadways only trigger updates to curb ramps that cross the road, or do they also trigger sidewalk crossfall and driveway upgrades, crossfalls, or ramps crossing the driveway? So primarily any type of roadway alterations, which is resurfacing or a pavement replacement, the primary requirement is curb ramps. Driveways are not included and sidewalks are not included. But as far, but sidewalk crossfall and driveways, so yeah. So to answer your question, sidewalks and driveways are not required as far as roadway alterations or alterations in the federal guidance definition. There's another question. Does utility trenching and sidewalk trigger ADA? And does the utility agency have obligation to do ADA improvements, or is it on the local agency? So, and this ties into a previous question that I think some people, one person was asking is, well, if someone is doing the work, in, let's say, a city right away, who's responsible? And the answer would be whoever is doing the work. So whether it be Caltrans doing the work or the city or the county, if Caltrans is doing the work, then Caltrans is responsible 100% for anything that we touch. So as far as utility trenching, unfortunately, because this question has come up a lot, Because if you're just trenching, let's say 1 foot wide trench or 2 foot wide trench, you're not really affecting anything, right? So I actually asked clarification from Federal Highways. And they said that as long as you're touching the ADA facility, let's say the curb ramp or the sidewalk or the driveway, whatever you touch, oh, it's kind of like going to a glass shop. Whatever you break it, you bought it. So in this case, you break it or you touch it, you fix it. So what if you trench across a curb ramp, then you're required to fix the curb ramp. If you're trenching across a sidewalk, whatever you're trenching of that sidewalk, whatever you replace, that segment of sidewalk that you're touching, you need to upgrade to current standards. There's another question. So just a thought would be super helpful in Caltrans and to encourage local agencies, public works departments to adopt matching standards to mirror Caltrans. Yes, it's highly recommended, definitely not mandatory. And if you ask me personally, it would be the easiest thing to do because Caltrans, we have spent a lot of time and work with a lot of our local partners and everybody to come up with the standards that we have pieced together. And so definitely it's more than open for local agencies to adopt. And Caltrans, we are here for you guys. We have, if you guys, I'm not sure if you guys have heard, but well, maybe you guys have. Like we have another DIB 89, which is the separated bikeways guidance. So Caltrans, we don't really build too many bikeways, or especially separated bikeways, but per the request of local agencies and jurisdictions, they have, because to put something like that together does take a lot of work and a lot of time. And since Caltrans being state, we do have a little bit, we have deeper pockets, I guess, or deeper resources. So we did agree to put out that DIB 89 for separated bikeways for local agencies to use and adopt. So same thing with DIB 82 for the ADA standards. Definitely you guys are more than welcome to adopt it. But the key thing to keep in mind, as we mentioned before, is that if you guys adopt it, you have to officially adopt it. It has to be in your ADA transition. I wouldn't say transition plan, but in your ADA guidance, your official ADA guidance for your agency needs to officially adopt either ADAG, PROAG, 2010 standards, CBC, or even the DIB. And as long as you officially adopt it, definitely you can use it. I do not recommend. Well, you guys are more than happy to grab what we have and do whatever you guys want with it too, but that takes time and effort as well. So not as recommended, but definitely you can use wherever we have. Another question in the chat: is the Caltrans or local agency responsible to fund upgrades of locally owned curb ramps when a state's paving project is impacted, marked, and for marked and unmarked crosswalks? So once again, whoever is initiating the project and doing, let's say, the alteration work, then let's say if it's Caltrans, then Caltrans will be required to upgrade those curb ramps adjacent to the alterations. So whether it be within Caltrans right away, local agency right away, or even a private property owner. So it will be on. We've worked with local agencies to work something out, or even a private property owner. Especially private property owners, sometimes we get some ones that aren't too keen on Caltrans, so they are resistant to give us a temporary construction easement to work on their property. So another question, which is another good question, because I know this is kind of confusing. And it says, what is the maximum slope of curb ramp if the length is 15 feet or less? So if it's 15 feet or less, the maximum is 8.33%, which is pretty, it is consistent with all the federal guidance, whether it's ADAG, UFIS, or whatever. Maximum is 8.33%. So that's why when we tell our designers to, when they're designing and they want to invoke this PROAG rule, we tell them to design at 15 feet 2 inches just in case, because concrete may shrink or the contractor may sneeze when he's actually like smoothing out the ramp or whatever. And because 14 feet 11.5 inches does not allow you to go above 8.33%. It has to be at 15 feet or more. So yes. So maximum slope is less than 15 feet or less is 8.33%. Oh, another good question is, how do I obtain a copy of DIB 8206? I was going to mention, but I totally forgot. It's in Caltrans's internet page, but definitely I can send a link to.
It's also located on the presentation as well, Anthony, on the slide before you.
Oh yes, that's
So
right.
yeah, so you click on that, it's going to bring you directly to that that copy of the DIB.
Oh, perfect. Okay, thank you. Yeah, so you guys feel free to go through it and definitely let us know if you guys have any questions. So let me see. So here's a longer question. Is there a time frame in which we are required to have all curb ramps and city facilities updated to current ADA standards? How does this play into the development of new standards? As in the past, the target is a continual moving target. And also, how does it relate to items that were in compliance at the time of construction and are not needed of structural repair, such as a 91 compliant curb ramp? So from what I understand is, and Kathy, correct me if I'm wrong, as long as you have a transition plan, there's no set timeline to fix everything, but that's the main purpose of the transition plan. And the thing is with the transition plan is, it's really, and it's kind of an odd term called transition plan because it makes me think of what you're transitioning from and to, right? But what it really is just at the very least an inventory of all the ADA facilities within your jurisdiction, where you list off whether they're compliant or non-compliant. And ideally at the end of whatever your plan is or your schedule is, everything should be moved over from non-compliant to all compliant. But still, you still need to keep that transition plan to list off so you know which ones are all compliant. One thing to keep in mind is if you guys don't keep a good transition plan or don't maintain an updated transition plan, I don't know if you guys have heard, but Caltrans, we have got sued with a class action lawsuit, and this plaintiff is a watchdog group that has been going around suing many different jurisdictions. So a quick thing with Caltrans, in 2006, we were sued, which was quite a few years ago. After 4 years of litigation, in 2010, we settled for $1.1 billion with a B, which at the time was the largest 8A settlement in US history. Luckily, I wouldn't say luckily, but ever since then, because that was in 2010, we're not the number one anymore. In 2015, the city of LA, not the country, not the state, not the county of LA, but the city of Los Angeles, they settled for $1.4 billion. But that was in 2015. But as recently as 2019, the city of New York, they got sued and they settled for $1.5 billion. So currently they hold the record for having the highest ADA settlement in US history. So that's why it's so important to have have and maintain a good transition plan, because unfortunately we had a raggedy transition plan when we had that class action lawsuit. So now we're still trying to maintain our transition plan. So, and for us, since we, as part of the settlement, we agreed for 20 years to fix everything in the state. But if you guys have not gotten sued yet, there's no set time, but the key thing with the transition plan is to create that schedule to say when you're going to do it, and you need to keep up with it.
Yeah, I agree with you. It's also important to document that as well. If you can't resolve that, the curb ramp to be fixed or to be ADA compliant within that year or whatever year that you have set yourself for, you definitely want to document that. The reason why you're not able to make that curb ramp ADA accessible, ADA compliant, definitely document that. Documentation is very important when it comes to any plan, if you're unable to fulfill that deadline as well.
Awesome, thank you. Then, and the second part of this question is, how does this play into development of new standards? So it could go either way. You could go, and one really good thing is, especially with Caltrans in our 6th version of our DIB is one of the few times where any of our standards is actually less strict as opposed to being more strict. And case in point is that that 15-foot rule, where now if your curb ramp length is 15 feet or more, then your slope could be more than 8.33%. So there's a hand raise. Is there a quick question you want to jump in?
Okay.
Wu Jie?
Go ahead. You can come off mute.
Okay. Well, while he's figuring out the mute. So let me see. Oh yeah. So as far as standards, so the 2010s, that was from 11 years ago, and ADAGs was quite a few years ago and whatnot. So you could it depends on how you adopt your standards. So and so really it depends. If you're going to adopt a new standard, you guys need to state in your guidelines how you're going to deal with it. So if you want to set a date, let's say like a safe harbor date, March 15, 2012, then that's a date. Then you can say everything after that will be current standards, everything before that would be the old standards. So as long as and what we found out from the federal government is as long as you say what you're going to do and how you're going to do it and you stick with it, you should be okay. They're not going to say, well, how come you didn't upgrade your 100 curb ramps that were done in the 1990s? Well, if you say that, any curb ramp that was built before March 15, 2012, then, and that's what you're doing, that's what you're observing, then technically you should be okay. They're not going to question why you picked a date or whatever. They just want to make sure that you're doing what you said you're going to do. All right. So another question says, milling and overlay is listed in both 3R and CAP-M. How do we differentiate the two when applying the rule of crosswalk? So that's a good question. So just real quick, CAP-M is Caltrans terminology for mill and overlay. And 3R is what we're saying, roadway rehabilitation and restoration and removal and replace and everything. I've said more R's than more than 3 R's, but technically that's what it entails. So, and technically it really depends on the specific type of work you're doing in a particular location. Because yes, sometimes we have 3R projects, and 3R projects, you could have a CAP-M project, which once again is a mill and overlay, where you're actually grinding out some of the asphalt pavement and putting some new asphalt pavement back on top, or you could even just put on top without even grinding some out. So, but if you have a 3R project, which is totally removing the pavement and putting it back in, there should be, you don't want to have to program a project just to do mill and overlay for one portion of the street where the pavement is okay, and another project for another one, we're actually removing the whole project. So for Caltrans, we just use the highest type of classification, which in this case would be 3R, and everything that falls under it falls under it. But let's say between block A and block B, you're just doing a CAP-M, then you won't have to, you're not required to fix the grade or grade of your crosswalk. But if block B to C has your full replacement of pavement, including removing of the base and everything, then for those intersections, you would have to fix the grade and the crossloop. So technically you can pick and choose, and the key thing is, as long as you're following the requirements of that particular type of work that you're doing in that particular segment or that location, then you should be okay. All right, I see some more raised hands. Anybody want to ask any questions?
Yeah, we'll make sure we unmute them.
You can unmute Ivy.
Hi there. Thank you, Anthony, and everyone for the presentation. My question is, I'm looking at the DIB 8206, and my question is, are these actually just still guidances? But then if we're on Caltrans property, which I work for the city of Oakland, so there's a lot of freeways around here. So we have to, it's more of a standard then, right, to follow DIB 82. And I'm reading like on the first line in the subject says effective immediately. Caltrans Department of Transportation Accessibility Design Guidance, DIB 82, has been updated to this. Well, it says guidance, so I'm still a little unclear about standards and guidances when on Caltrans right away.
Yeah, you bring up a good point, because technically there is a distinct difference between guidance and standards. So, but in in short, the DIB is our standard for everything ADA. So if you're doing any work within Caltrans right away, then you would be held to the DIB, the standards in the DIB.
Mm-hmm.
Hopefully it answers your question. Yeah, it's almost too general, but hopefully, because yeah, it's there's a lot of background and depth to it, but hopefully that answers your question.
Yeah, yeah, mostly because I'm looking. I've used the DIB, the HDM DIB 80. I forgot the number, but usually they have it bolded or underlined saying this is mandatory or advisory.
Yeah.
So and then neither bolded or underlined. So meaning that it's not a standard, but it's also still in the DIB. So that's why I wonder if there's something similar with the ADA DIB.
Oh, yeah, that's a very good distinction. And so what she's referring to is when she's at HDM, that's Caltrans' Highway Design Manual, which is our design guide for anything roadway design, which does include some ADA features, so to speak. So and most of the document, it's a manual, so a lot of it is just written in plain text. But there's certain ones which we formerly called mandatory and advisory standards. Now they're just called bold and underline. Those were ones where if you do not follow the things that are bold and underlined, then you have to get an exception for. So which is correct. And so with the DIB 82, technically everything in there is a mandatory requirement. Although it doesn't say, but that's how. That is the definition that we've gotten from the author of the DIB 82, is that if you don't follow anything within the DIB 82, then actually in the first appendix in the back, there is a section and also a cover sheet that talks about exceptions to ADA standards, which follows pretty much the federal standards. And the difference between the DIB and the Highway Design Manual, the HDM, is that the HDM standard are actually, once again, Caltrans conservative standards. It's not a standard that is a federal standard. One case in point is, I think there was also a question in the chat too, is the difference between 1 curb ramp and 2 curb ramps. So in the Highway Design Manual, it requires 2 curb ramps to be placed at every corner, as opposed to a single diagonal curb ramp, which is more common to everybody else. That is not a federal standard in anywhere or any guidance for the 2 curb ramps. But Caltrans, we felt, and especially in our discussions with federal highways, there is a high preference for the 2 curb ramps. And so as we have officially adopted that in our Highway Design Manual, as opposed to our DIB, which is, and the difference is the DIB 82 is the guidance that we've selected to follow, the federal guidance that we have selected to follow, whereas the Highway Design Manual is a Caltrans preferred guidance.
Okay, thank you, Anthony. Do we, any other questions on the floor before I want to see give Daniel an opportunity to address some of his questions too? Any more questions on the floor, Sherry? I don't see any. Nope. All right, Daniel, you want to take a few questions?
We do have a few, Kathy. Just a moment.
Sure. Okay. Sorry, I didn't hear you.
Joan, you can come off mute.
Hi. Yeah, thanks for taking my questions. So I just want to have a clarify about where there are where the roadway slope is, say, greater than the ADA maximum 8.33 slope. So the curb ramps on those areas can be the same as the slope of the roadway. Say the roadway has 16%, the longitudinal slope. What the slope for the current would have to be? Can that follow the slope of the roadway in terms of the I guess
yes, good question. Here, let me share.
Can you clarify that, please? Thank you.
Yeah, no problem. Yeah, because I know it's I know one, it's a shock when I first heard about it, and two, it does get a little bit confusing. So there's two factors at play here. One is the grades for the sidewalk itself, and as we were saying that, you know, in the draft ProAg guidelines, it says that if the sidewalk is within a street or highway grade or prism, then the sidewalk slope can actually match the general grade of the roadway. But if it's not, like, once again, if it's a walkway that goes to a building or to a restaurant or something like that, or in housing development, then the running slope of that that walkway can't be more than 5%. So this is why we want to show this picture, because previously, before this standard was adopted in the draft ProAg standards, or ProAg proposal, we were building these type of walkways over here, and these walkways here to keep this running slope here no more than 5%. So, and when you can see here, this is a lot of work, a lot of engineering, a lot of money just to meet that one standard. So, and that's why the people at ProAg, we thought, you know what, yeah, sometimes these standards aren't really practical, because especially if you're in a really hilly area, you know, people would normally expect to encounter steep grades if you're in a really hilly area. If you can't maneuver it, then most likely you find other means of getting through the area. But so that's why we ProAg came up with the fact, or the standard, to say that, you know what, this is probably overkill and a little bit too much and not practical. And this is just because this is an example of where we're going under a bridge. But let's say, yeah, like you were saying, if you're in a really hilly area, you know, is the whole area just going to be one giant structure for sidewalks, which is, once again, not practical. So in this case, as long as the roadway is, you know, the sidewalk is next to the roadway, then technically we won't have to do this. And if this is like 8% here or 16%, like you said, the sidewalk can be 16%. So that's for sidewalks. Now, as far as curb ramps, so in here, and yeah, this is a rough sketch in CAD. So you'll have to squint your eyes and imagine that this is the curb ramp itself, even though it looks like it's a sidewalk. So let's say it's the curb ramp. And if your roadway is 5% and you use our Caltrans conservative slopes, then it would show that your ramp, it will calculate out to where your ramp is 28 feet long, which is a long ramp, right? So, but if you do the federal standard 8.3% at where the roadway's at 5, and the ramp, then like I said, yeah, it's hard to see because this is just a profile view, but this is the ramp over here. It'll be 20 feet 72 inches. But with Caltrans standard, the ProAg portion ProAg we have actually adopted, it says that if you're in a really hilly area and it's going to be really long curb ramp, then you know what, just keep it at 15 feet, or like we said, we recommend 15 feet 2 inches. Then whatever the slope is whatever that slope is. So it could be 16%, could be 50%, doesn't matter what it is. As long as your ramp is at least 15 feet, then you're okay. And
So-
reason being, no, was there a question out there?
Yeah, I'm sorry. So this is really just for the ramping of the sidewalk, right? But what
Correct.
about the curb ramp itself?
Oh, yeah, well, ramping of the sidewalk is the curb ramp. So, yeah.
The curb ramp is far within this.
Yeah, so this would be the top of the curb ramp, and this would be
I
the
see.
bottom of the curb ramp.
Okay,
Yeah.
got it.
Yeah, thanks for asking for clarification. Yeah, because I wasn't sure. Yeah, if this was too clear. So,
Okay.
and the philosophy with this is, and the key thing is with this example here, with all these three scenarios, all three of these are acceptable. So it depends on the designer of what school of thought that they want. if they're okay with a long curb ramp, then that's fine. But if they're under the impression that, hey, you know what, we don't want to have a person in a wheelchair to have to go up 30 feet or 40 or 50 feet without having to stop, because landings are not required inside the curb ramp. It's only at the top or the bottom. So this being that long, person in a wheelchair can't stop until they get to the top, which is after 30 feet or 40 feet. So the school of thought is, well, how about we just shorten it to 15, no more than 15 feet, or actually, no, sorry, 15 feet or more, and they'll just struggle for 15 feet, but after that, they can actually stop and rest. So depending what school of thought you're working with, then you could, pick and choose which standard that you want.
Yeah, it's hard for me to visualize this, but I see curb ramps and, really hilly area. But at the location where their actual curb ramp, they build the curb ramp to the standard, 2% slope at the at dome area.
Yes.
But I don't see how the wheelchair can actually maneuver the slope that adjacent to the curb ramp area.
Oh, yes. Yeah, and
It
that's where
doesn't make sense to have curb ramps there. That's what I'm saying.
yes, I totally agree. Yeah, I'm trying to look for an example which hopefully should be easier to see. What's a plan view of a sample curb ramp where we apply that rule? And
No, there's actually location where it's at I'm in Castro Valleys on Miramar and Page.
okay.
If you go to Google, you see those curb ramps. They don't look to make sense to me.
No.
So my husband's on wheelchair. That's why I'm thinking there's no way.
Oh yes. So, and that's the thing, and that's why it's really important to have a transition plan. And that's one of the main reasons why Caltrans is settled. We didn't continue fighting the case because we thought we were doing everything right. But then when we actually looked into it, a lot of things were wrong. So because of that, so with that said, just because it's out there doesn't necessarily mean it's right.
Yeah. Okay.
But just to show an example, and hopefully it's easier to see, to where this is a case B curb ramp. We have a ramp here, a landing, and another ramp here. So here we have 15 feet, 2 inches, or 15.17 feet, and the slope of this ramp is 11.9%, which is 100% acceptable based on this passage in PROAG.
Yeah, thank you.
Hey, no problem.
We can take one more question before we continue with the completion of this training. If your questions were not addressed during this training, please reach out to either Kathy or Daniel after the training, and we will provide you with an answer. Our contact information is listed on slide number 2. Thank you. You may proceed.
Thank you, Annette. Well, you're popular, Anthony. You're a celebrity.
ADA is a huge issue, I think, with a lot of people, not just Caltrans.
Yeah, we might need to schedule a different webinar just for you. Daniel, do we want to go ahead and take one more questions? And I say we have allowed to have one more questions before we wrap it up.
Yeah, sure, I have one. One moment. So somebody asked, does the transition plan need to include sidewalks in public right-of-way as well as residential driveways in the public right-of-way? So yes, both sidewalk and residential driveways would be identified as potentially separate priorities in the self-evaluation plan, since they receive different levels of access from the public. And as such, they may be located near facilities where accessibility is impacted differently, such as, well, in a suburban area compared to something that is more heavily accessed by persons with disabilities, such as a hospital or a senior home. So obviously the hospital or senior, the location where the hospital or senior home is approximate to would require a higher priority within the evaluation plan and a sooner precedent for removing any barrier to make it ADA compliant.
All right, thank you, Daniel. All right, good job, everyone. Anthony and Annette, as well as Daniel. I will go ahead and move forward to slide number 31. All right, slide number 31. So, all right, so we're at the very end of our webinar. So slide number 31 state achieve ADA administrative requirement, okay? All public entity must conduct a self-evaluation plan, okay? They must provide a public notice about the ADA, which is American Disabilities Act, okay? Right below that, we have the public entity with 50 or more employees are also required to designate an employee to oversee Title II compliance, establish a grievance procedure, develop a transition plan if structural change are necessary for achieving program accessibility. Okay, so in conclusion, to eliminate disability discrimination and achieve ADA administrative requirement with this law, these are the requirement that we have want our local agency to keep in mind, that if you have less than 50 employees, then you want to make sure you still need to conduct a self-evaluation plan and provide notice about the ADA. Any entity that's 50 or more employees, then you designate a coordinator. You would need to have a complaint slash a grievance procedure, as well as a transition plan. Okay, so any structural change to any existing facility are necessary, then this is where you want to develop and carry out in the transition plan to make it to make that program accessible, not just for your internal staff. You also want to make sure you do it for your the public as well. Okay, so the next slide we have, which is slide 32, we have a couple resources to implement the ADA compliance. We have the Caltrans Division Local Assistant ADA website. And right below that, we have the Caltrans Local Assistant Procedure Manual, LAPM, is where you'll find information about the ADA program slash section 504, okay? And the third one is the Caltrans Division Local Assistant blog. I will encourage you all to go ahead and subscribe to this Caltrans Local Assistant email list. And the purpose for that is that on our next training, we do plan to make that email announcement or make that announcement on that blog. So any future upcoming local assistance related to civil rights, such as ADA or any civil Title VI or whatever the case may be related to civil rights, we do plan to make those announcements through the Caltrans Division Local Assistant blog, okay? So I would encourage you all to subscribe to this email list, so that way we have an upcoming training, we will go ahead and make sure you all will get that announcement as well, okay? So right below that, we also have the Caltrans Office of Civil Rights ADA Infrastructure Program, ADA website. I mentioned this earlier regarding how you will file a complaint with Caltrans right away. That's the website you will, when you click on that link, it's gonna bring you directly to the ADA program website with Caltrans. So that is where you will go ahead and file a complaint that's related to Caltrans right away, okay? And the next screen that we have, which is slide 33, it says some useful links. If your agency want to provide any training to your staff or even to the public, you can definitely more than happy to use those links that was provided. Again, it's provided for you as as a resource. So you right click on that, it's going to bring you directly to the website. So all that is available for you at slide number 33. And I just want to thank you all for participating in today's ADA Section 504 webinar. So your feedback is very important to us. So evaluation link will be available at the chat box. An ADA certificate will be provided in the next few weeks to all attendees. Okay. Now this webinar is also being recorded as well, and we should able to get that posted in the next couple of weeks on our Caltrans Division Local Assistant ADA website. The next few weeks. So we're also going to be, I know Daniel mentioned this earlier as well when he was addressing the Q&A panel. We will go ahead and post the Q&A, the frequently asked questions or the Q&A documentation on our website. That way you all will have a copy of that, as well as the presentation on this webinar that will be available in the next couple of weeks as well. Okay. All right. Again, if you have any questions, please do reach out to Daniel, myself, and Ned. Anthony, contact information is not on there. So maybe Anthony, you can share your contact information, or you can just reach out to me if you want to. I can share Anthony contact information, but we're all here to further assist you guys. And thank you all for attending today's webinar. And Sherry, you can stop the recording.